Court does call the case People versus Serrano Johnson.
Public Defender Chelsea Vergils with and on behalf of Serrano Johnson. Mr. Johnson, please state your name.
Serrano Johnson.
Right out of the gate, this case wastes absolutely no time. We're not here for a long trial. We're here because Mr. Johnson violated one of the most basic conditions of bond: do not consume alcohol. And when you're out on bond, that condition is not a suggestion. It's a direct court order. So the stakes: immediate, real, potentially jail. Judge Simpson is already setting the tone. This is a probable cause conference, but the spotlight instantly shifts to credibility. Mr. Johnson admits he drank, but that's not where the drama lies. The real issue is whether he told the truth about it from the beginning. Because in court, especially in bond situations, honesty is currency. Once you lose it, everything becomes more expensive. And here's what makes this explosive. This isn't just about 2 beers. It's about whether he tried to manipulate the system by claiming he drank O'Doul's Nandostrin, non-alcoholic beer, instead of actual beer. If the judge believes he lied to community corrections, bond revocation is absolutely on the table. So the real question becomes, is this a man who made a mistake under pressure, or someone who thought he could outsmart the math? Stay locked in, because Judge Simpson is about to dissect this story piece by piece.
I mispronounce your name every time, sir. It's okay. I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause conference. Regarding that, we are asking for an adjournment to show compliance with his bond conditions. I understand he's had a violation that we are prepared to deal with today.
All right.
Mr. Johnson is prepared to plead guilty to violating his bond by consuming alcohol on July 7th.
I'll accept that. Before imposing any sentence regarding that, I'm going to ask this question. He presumably has indicated that he had O'Doul's. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That is correct, Your Honor.
Then why'd you tell everybody O'Doul?
I had O'Doul's first.
This is where the courtroom temperature rises. Judge Simpson isn't confused. He's testing consistency. The defendant first claimed O'Doul's, which contains trace amounts of alcohol, but not enough to spike someone's blood alcohol level the way his test indicated. So when the judge asks why he told everybody O'Doul's first, he's not casually curious. He's pointing out a credibility fracture. And here's the legal reality. Lying to community corrections isn't just embarrassing, it directly affects bond status. Courts rely heavily on compliance officers' reports. If those reports are based on false information, that's a serious problem. Notice how the defendant says he omitted the beers. That's a soft word. Omitted. But omission in this context equals deception. The judge immediately reframes it as a lie. That distinction matters legally and psychologically. Would you call this panic under pressure or calculated dishonesty? Because from the bench's perspective, intent is everything. And once a judge thinks you're playing word games, the benefit of the doubt evaporates fast.
But I needed beer.
You had O'Doul.
Yeah. I don't look like what I'm going through.
No. Hey,
I had O'Doul's.
Are you
I had
tell me that? So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beers.
Hold it. You know what, sir? Don't play fast and loose.
I got
The
it.
story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had duels. To get to the level that you were at, you would have had to have 25 duels in an hour
No, I didn't have
in
that.
order to reach that level,
Sure.
and could not have used the bathroom because you couldn't eliminate in order to get to that level.
This moment is brutal and strategic. Judge Simpson walks through the math. To reach the measured alcohol level from O'Doul's alone, Mr. Johnson would have needed to drink about a case, roughly 25 bottles, in an hour without eliminating any fluids. That's physiologically unrealistic. This is how judges dismantle narratives. They don't argue emotionally, they calculate. And here's the bigger issue. Once the judge proves the story impossible, he shifts from you omitted to you intentionally misled. That language escalation matters. Intentional deception signals risk. If someone lies when confronted with scientific evidence, what else might they lie about? This is no longer just a bond violation. It's a trust violation. And think about this. If you're on bond for a weapons-related charge, as the prosecution later mentions, how much tolerance do you think the court has for dishonesty? Not much. Not at all.
That's how stupid your story was. And now you can't even, you can't bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
Regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders.
Well, I don't think he's going to have a choice on that, quite frankly, Mr. Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really?
He's here.
No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. Your Honor, he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a SCRAM tether. Again, this would be his first violation. And he's asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. I think it's just a couple of years. We would note that in this case, he allegedly was found not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I
The
do.
way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remanded.
And there it is. Bond revoked. Immediate custody. For viewers who may not understand how fast this can happen, this is textbook. When a judge believes someone violated bond and lied about it, Revocation is a lawful and common outcome. Bond is conditional freedom. Violate the conditions, freedom disappears. Notice what tipped the scale. It wasn't just drinking. It was the refusal to fully own the deception. Judge Simpson even says he first has to admit that he has a problem. Courts often view acknowledgement as the first step toward rehabilitation. Without that, supervision feels meaningless. Now ask yourself, if he had simply admitted to drinking from the beginning, does this go differently? Possibly. Judges often show leniency when defendants are candid, but once the judge says he's not buying any of that, the door is nearly closed.
Address bond, Your Honor.
Well, what are we going to be doing on the case first?
I got your green sheet. I forgot to give it to you.
All right. You're asking for an adjournment of the proper
Yeah.
cause.
Yes, Your Honor.
I'll give you a date and moment depending on the outcome of your bond motion. Go ahead.
Your Honor, I've provided the court with a letter from Second Baptist Church, Reverend George Waddles. The pastor is present here in court today along with
see.
my client's
Hello,
family
Pastor.
members.
Go ahead.
If released, he would live at apartment 1 in Ypsilanti. By profession, he's a chef. He's been a resident of Michigan approximately 20 years. Like I said, he attends Second Baptist Church. He also volunteers at Hope House. And Your Honor, he's a caregiver for family members. So he has a lot of things going on. He volunteers in his community. I understand from the last hearing that he was not candid with the court as to his consumption of alcohol. But
Well-
and I'm not,
Not candid would be an understatement. I mean, he just outright lied.
well, I wasn't there.
That makes it no less a lie.
The defense attempts damage control in the new hearing, presenting a pastor, family support, community ties, all powerful mitigation tools. But Judge Simpson zeroes in on the core issue again, honesty. When counsel says, well, I wasn't there, the judge responds, that makes it no less a lie. Translation? Character letters don't override courtroom credibility. Legally, bond reconsideration focuses on risk. Risk of non-compliance, risk to the community, risk of flight. Support systems help. But if the judge believes the defendant manipulates the truth, that risk remains. And this is a fascinating dynamic. The pastor's letter praises him. The prosecution says he's not a bad person, but the court is concerned about behavior, not reputation. Who weighs more in your mind, community service or courtroom candor?
I'm asking if you want to hear from him.
I'll-
A humble apology.
I will certainly hear from him, but not if he's gonna sort of spew that garbage he was giving me the last time, because that's how he ended up in custody.
I apologize, Your Honor. I panicked. I apologize. Yes, I did consume.
Pardon?
Yes, I did consume, of course. But yeah, I panicked when I was talking to the guy. I apologize for our last encounter.
You consumed alcohol and when I tried to get you to just tell me that, you just lied to me. Right?
Yes, I tried to go back and you told me.
Pardon?
I tried to go back on it, but it's too late. I had already said it. So, yeah. I apologize, Your Honor.
So on the date that you drank, what happened?
What was the trigger? What made you drink?
Working on somebody's funeral arrangements and drink a couple beers, drink a few beers.
Okay, so
So
did you have any O'Douls
at first, but
at first? Okay. How many O'Douls did you have? 6. And then you had how many?
Labatt's about 4.
4.
Sure.
Okay, now you know that's different than what you told me.
I was trying to tell you, but you told Mr. Allen
You were trying to tell me what?
nothing. That's what I
No,
told.
no, 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 no. Let me tell you what you said, because I remember it very clearly. You told me that you had 6 O'Douls. I told you to get to the levels that you were, if you were just drinking O'Douls, because you were insistent on that, you would have had to have a little over a case of O'Douls. Remember that?
Yes.
Then, at that point, you realized, well, he looks stupid, but he's not.
This exchange is sharp. Judge Simpson makes it clear he remembers the prior hearing word for word. Judges do that, especially when credibility is tested. When he says, he looks stupid, but he's not. He's highlighting the turning point, the moment the defendant realized the math didn't add up and pivoted to admitting 2 beers. That pivot is what damages credibility most. It suggests the admission wasn't voluntary, it was forced by logic. And notice the pattern. First 6 O'Douls, then 2 beers, now 4 beers. The story evolves. Courts hate evolving stories. If you're the judge, do you see growth or ongoing minimization? Because in bond hearings, consistency is survival.
And then you started telling me that you had 2 beers. Remember that? What?
Yes, Your Honor.
And I knew, given the level that's on here, that wasn't true. Now, the other things that you told me was that you were in treatment. Remember that?
Treatment. He's trying to go to treatment.
Well, okay. Yes.
I'm just trying to,
I don't understand the question.
You said it to me.
he said at the
Did
last,
you or did you not tell me that you were
I wasn't
in
there.
treatment or had started treatment?
We were looking for a place to go to treatment. That's where we're starting, we're trying to go. Yes. My insurance is different.
Let me ask you this. When you made the statement about treatment, were you trying to get this court to believe that you were in treatment?
No.
You're saying no?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
Self-incriminate myself. I don't know what you want me to tell
You
you.
don't want to self-incriminate yourself?
Already done.
So see, okay. And I know you know this, but I'm just going to remind you. That's what happens when you lie.
And I apologize.
This is the moral core of the hearing. The judge explicitly connects consequence to deception. That's what happens when you lie. It's not about punishing alcohol consumption alone. It's about preserving the integrity of court supervision. There's also a Fifth Amendment tension here. The defendant mentions self-incrimination. But here's the key legal clarification. When you're addressing bond compliance, you can't avoid answering direct supervision questions by hiding behind the Fifth. Bond is conditional. Judge Simpson also states he knew from the moment O'Douls was mentioned. That's experience speaking. Community corrections officers and judges see patterns repeatedly. Do you think this apology feels genuine or reactive? Because sincerity can influence bond decisions, but only if it comes early enough.
I know a whole lot more than it appears that I know. And the moment you told the people at community corrections about O'Douls, I knew you were lying. That was my first start. Now, if you can tell me that you can put down about a case and 2 or 1 beer, about 25 beers, and not go to the bathroom, because that's the only way that was gonna happen with those duels.
That
Yeah, so that's was kind of the stupidity of the law. And then it just got worse for me. And then as it got worse, then you ended up going to jail.
I get it. Oh, I get it.
So how are you going to get in? You have insurance to cover treatment.
We're working on that. We just changed insurance, so it's not clear about.
His family's here, Your Honor.
They're
Oh, I
working it
know
out.
they're here, but you told me, Mr. Brown, at the bench that he's got insurance that will cover his insurance.
They're-
And I'm just asking, will his insurance cover treatment?
We're working on that now to get a definite. Yes, it will cover some sort of treatment. Yeah.
Anything from the people?
Your Honor, people do believe that Mr. Johnson is in dire need of treatment. We do have some concerns after the statement today. He may still not understand the extent he needs treatment, Your Honor. And I did have a chance to look at the letter that Mr. Brown provided that was from Mr. Johnson's pastor. It is a lovely letter and talks about the lovely things that Mr. Johnson has done. And the people aren't arguing that Mr. Johnson is a bad person. At no point that we allege that. We're alleging that he committed a crime, and it would appear that perhaps the root of that could have been an alcohol addiction, Your Honor. And we think about treatment, that situation could reoccur. And it's not clear that Mr. Johnson understands that or the need for treatment. So we do have some concerns there.
Now the focus shifts from punishment to prevention. The prosecution acknowledges he may not be a bad person, but they emphasize risk of recurrence without treatment. That's critical. Courts increasingly frame substance-related violations as treatment issues rather than purely punitive ones. But treatment requires acknowledgement. Notice both sides agree on one thing: he needs help. The debate is whether he'll comply outside custody. This is where bond conditions like SCRAM tethers come in. A SCRAM tether monitors alcohol consumption 24/7 through transdermal testing. It's strict, it's invasive, but it allows conditional freedom. So here's the engagement question. If someone shows signs of alcohol dependency but has community support, do you lean toward incarceration or structured monitoring? Because that's the balance Judge Simpson must strike.
Anything else, Mr. Brown?
No, Your Honor.
Johnson, here's what I'm going to do. I'm going to first of all adjourn his probable cause conference to August 7th, 2025, 9 a.m. With reference to his bond, I will set his bond at a $25,000 personal recognizance bond. On your release, you are to report to the Department of Community Corrections for placement on a SCRAM tether, because you were on a
Correct.
You're going to go on a SCRAM tether, so I'm going to monitor you 24/7 for any alcohol consumption. I'm also going to order that within the next 10 days, defendant is to be enrolled in treatment. He is to notify the court that and the prosecutor's office that he is in treatment.
How many days?
He's got 10 days to do it. If he doesn't get in, I'm issuing a warrant, or he might as well just come over to jail and turn himself in, quite frankly, because I'm going to issue a warrant and I'm going to have him picked up.
Understood.
You understand all of that, sir?
I do.
Thank you.
Thank you.
No, just, we'll do that. Okay. Thank you, sir.
This is the final ruling, and it's measured. Bond is reinstated at $25,000 personal recognizance, meaning he doesn't pay up front but promises to appear. However, strict conditions follow. SCRAM tether monitoring 24/7 and mandatory enrollment in treatment within 10 days. Fail to comply? Automatic warrant. This outcome shows judicial balance. Judge Simpson punishes dishonesty with temporary custody but ultimately prioritizes structured rehabilitation over prolonged jail. Legally, this sends a message. Accountability plus oversight equals opportunity. If he complies, this moment becomes a turning point. If he doesn't, the consequences escalate fast. Professionally speaking, this case highlights 3 themes. Credibility matters more than excuses, math defeats weak lies. And courts are willing to support treatment, but only with transparency. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.